Who wants to speak about Dow Bonton? Good man for standing up. Thank you. Hey. It really is, in law school, the professors are not worried. There isn't a right and wrong. If the Supreme Court decides an issue 5-4, we need to know what the 5 say because that's now the rule for us. But it's clear that it's not clear. I'm more concerned about, can you tell me why Dick and Scumbag is not, can you spot the issues? Can you articulate? If the judges don't agree, they can't agree to kill a rat in a bathtub. So go ahead. No right, wrong.
Yes, action can be taken simply because this doesn't meet public concern, public safety. It was made in an official capacity at work.
Well, let's see if we have any disagreement about 1. If we don't have 1, we don't even get to 2, right? Does anybody disagree about whether or not this may have involved a matter of private concern? Burdick.
This recruit actually had a question on number 1. Does all the postings or just one posting have to fit public concern?
Good issue spotting. So you represent the officer. You're his attorney. I'm the judge. Make an argument for your client. Now, clearly, you have, and I know which one it is, and it's great. You have identified something that you think could arguably be a matter of public concern. Tell me what it is.
In our group, we were discussing whether officers and staff felt pressure to work political campaigns. As a taxpayer, if they're taking officers off the street and actually having their resources spent to someone else's political ideas and policies, they're not actually following and doing their job, so they're not protecting us. I don't feel safe if they're just working on a campaign, not protecting the streets.
Well, or just even, not even just as a time factor. It's hard for us in Alaska to understand, but what political campaigns? In the lower 48, there are sheriffs. Sheriffs are elected. So if deputy sheriffs are being pressured to support one sheriff over their opponent, that's a matter of public concern for me, too. That's like pressuring any vote, It's like using the job to pressure a voter, the voting right, the sanctum of the voter's booth. Good issue spotting. This was a real case. Went to the Supreme Court. The facts were exactly the same, except it wasn't a police officer. It was an assistant district attorney, public employee. And here's what the Supreme Court, it was Connick versus Meyer. The Supreme Court said, and because of Reno versus ACLU, whether or not it's posted on the internet communications are treated the same as others. And for a while anyway, our courts are going to be looking at cases like Connick versus Myers for how to evaluate these things. Because Reno versus ACLU said, just because it's an internet communication doesn't mean it should be treated differently for First Amendment or privacy protections. Okay, the Supreme Court concluded, as counsel argued so articulately and astutely, only the last issue even possibly touched on a matter of public concern. The remaining topics were internal workplace matters. We don't care. And they found that the DA was justified in firing Myers for insubordination because that if it had just been about that one matter and nothing else, probably couldn't have fired him. But because it was just one of the many, and they wouldn't give us a specific formula. What if it was 50%? But they said the circumstances, the context of this entire case under which it arose, it was clear he was just, Connick was just trying to foment dissent and get other people on his side and around. He wasn't concerned about that. He was trying to gather evidence of all of these things against his employer. If it had just been that, or he seemed to be genuinely concerned about the public concern about that versus getting stuff from employees that could be used against his employer, we might have viewed it differently. Okay, good issue spotting. Take a look at scenario 3 and discuss it in your groups before we break for lunch.